Good afternoon, all, and today's video and my next video are on how did these people, and who are they exactly, who intentionally killed Gulliver, my 30-year-old medically prescribed autism service therapy horse and 28-year trauma support companion. He was put in place in my life after I witnessed my late mother self-immolate and die of third-degree burns over almost 100% of her body on my father's front lawn. So this horse wasn't just any old horse that didn't matter. And to my almost 32 million views who have come to my channel, not only because I'm autistic, but because of my special interest in horses and ponies, part one will tell the story of who did it, who brought this about, and how did they get access to Gulliver. And part one is today's video. In part two, I will talk about how Gulliver died and why they intentionally killed him, i.e. murdered him, murdered my horse, Gulliver. So let's go. This is John M. Mueller on the left. And he is the person who brought about the intentional killing of Gulliver. And this is a picture, a public picture, he's posted to the public on Bradford County Telegraph Facebook page, where he is receiving a Pillars of Service Award from Santa Fe College during a March 4th luncheon in Gainesville. And when I'm done with this video, I would strongly recommend Santa Fe College take back this award. But I digress. Now, John Mueller is the owner of the Bradford County Telegraph newspaper in Stark, Florida. Now, John Mueller was aided and abetted by Charles Daniel Sykes. Dan Sykes, this is his Florida bar page. He is a lawyer here. This is him. He is a lawyer here. And Charles Daniel Sykes, public Facebook page, your hometown attorney. This is Charles Daniel Sykes. He aided and abetted John Mueller in bringing about the intentional killing of Gulliver. Another individual responsible for bringing about the intentional killing of Gulliver was right there on the left, Sergeant Glenn Ward of the Bradford County, Florida Sheriff's Office. And this is on Bradford County Telegraph's public pictures on its Facebook page. And it's in August 2025. It says that Sergeant Ward was named Florida's Drug Recognition Expert of the Year for 2024. Okay? Now, it's very interesting that this is being published on Bradford County Telegraph's Facebook page instead of the Bradford County Sheriff's page. But this is Sergeant Glenn Ward. There's another photo of Sergeant Glenn Ward here on the right with the Rotary Club of Stark, Florida. And this is, at least it was, on the Bradford Sheriff's Facebook page here. And so Sergeant Ward is receiving recognition here, and that's him on the right. This is Major Dawn Mueller. That's her. She is the one that was directly in charge of the intentional starvation killing of Gulliver. Right here. That's her. Okay? And she supposedly is responsible for animal control services, but when you starve a horse to death and intentionally kill him, you have to wonder whether she should be in charge of animal control at all. But that's her. Now, I'm going to explain each of those individuals' involvement in the intentional killing of my autism horse, Gulliver. And we're going to start by going through property purchase writings that comprise the binding agreement between John Mueller, Bradford County Telegraph Incorporated, my husband and I, to purchase the horse farm located at 2501 Southeast 143rd Way in Stark, Florida 32091. Now, John Miller's former attorney, John Cooper, informed my husband, David Petrano, that John Mueller sells and makes mortgages on distressed properties. Mr. Cooper was subsequently convicted of elderly financial exploitation crime and disbarred. Now, John Mueller and Bradford County Telegraph Incorporated's lawyer is Charles Daniel Sykes, who has taken Mr. Cooper's place. So, John Cooper was still on board at the time that this series of writings, text messages between the parties transpired. So on October 20th, 2018, Dylan Harrison, on behalf of his mother, Terry L. Harrison, texted my husband and said that basically he had not been able to get back to my husband. Now, this October 20th, 2018, and we took possession of the horse farm property on October 29th, 2018. So my husband asks Dylan Harrison, was your mom able to meet with Mr. Mueller yesterday? This is on October 23rd. Dylan Harrison responds, she was, he has been, and still is very sick. But, and this is John Mueller he's talking about, John M. Mueller, he is moving forward and said it could take a while to get all of the documentation together, waiting on him now. What documentation? Well, the documentation was a sweat equity agreement to purchase the property and assume Harrison's mortgage held by John Mueller and Bradford County Telegraph, Inc. So, my husband David replied on October 25th, Mr. Harrison, I spoke to Mr. Mueller yesterday afternoon, and he stated he would be contacting your mom today. He understands that the property needs to be cleaned up ASP. And then my husband asks, well, like, questions, that you would ask if you're being voluntarily put into possession of the property. What is your desire regarding the trailer and the refrigerator? Dylan Harrison responds, I will talk to Mom after work. Are you not wanting the trailer? My husband, David Petrano, says, it's your call. There's lots of your personal property inside the trailer, which I assume you will want to take with you. The fridge in the mobile home is also something I assume you want. My main concern is removing all the garbage bags and loose debris, which I hope to haul out this weekend. And we can certainly see Dylan Harrison's phone number here on these text messages. Now, John Mueller started dragging his feet and delaying. We took possession voluntarily on October 29th, 2018, and immediately began making the improvements. We had to fence, 4 horse paddocks, arenas, etc., which we had done by somewhere mid-December. So my husband David wrote to Dylan Harrison on November 8th and said, I spoke with Mr. Mueller this morning. I want to purchase the property. Mr. Mueller has agreed to allow me to assume your mortgage obligation, which includes outstanding interest for the period you have not paid him. Please inform me how much you want for the deed. Now, that series of writings and text messages documented the agreement. The agreement was in place at the time that we took possession on October 29th, 2018. And the last property appraiser valuation of the property prior to then was that the property was only worth $29,000 or so. So it was definitely a flooding swampland. In fact, it flooded 3 to 4 feet deep in the backyard, and then it flooded into the back shed and under the house, across the whole front paddock and the front arena. It was just one big flooding mess. So we put in $415,331.50 of sweat equity improvements. And this was filed in our first Chapter 12 bankruptcy, for which there was a lis pendens filed. The lis pendens is still effective because it continues to be in appeal posture. It's either going to be reinstated or appealed further to the 11th Circuit U.S. Court of Appeals, and the appeals toll the time under the lis pendens, thus it is still effective. And here we itemized everything. We itemized everything that was our property. This isn't some future speculation. This is what we actually paid for. And so anyone that sees those barns and sheds is on notice that we paid for all this here. This was our sweat equity under the purchase agreement. And this went on for 7.5 years with the approval of John Mueller, who did not live very far away, and he was constantly coming over on his golf cart to see the progress and what we had been doing. Oh, I actually went out and counted up every single item. And this is the total amount here of our improvements, our sweat equity improvements to the property at 2501 Southeast 143rd Way, Stark, Florida, 32091. This is a copy of Florida Statute Section 825.101 regarding financial exploitation of elderly persons and disabled adults. And in subsection 14A, it includes improvements to real property as the property of the elderly individuals. No ifs, ands, or buts. No other statutes. No common law. No real estate law. No fixtures law. Nothing. It says that the improvements to the property are the property of the elderly person. And so, because the property was flooded so badly, it was such a disaster. It was such a distressed property. With John Mueller's approval coming every day, he saw me putting up fencing and said, "Good job, keep it up." So we hired a contractor, and only later did we learn the contractor was one of John Mueller's renters. So it turns out, in hindsight, every time you're dealing with somebody who's a renter of John Mueller, or somebody whose parents' home is being sold to John Mueller, or some such, they're doing things that harm us and at the bidding of John Mueller. This has just been our experience. It's my opinion that I don't know how it's happening, but I think conclusions can be drawn about how it might be happening. Anyway, the contractor arranged they were going to make the property dry so that the horses were dry, the house was dry, I had a riding arena and turnout areas, and they were dry. So he brought expensive Sunbelt machines to the property. The next thing you know, John Mueller is appearing on his golf cart at the front of the property. He's surveying the progress, and then he hires this contractor right in the middle of our project, right out from under us. They load up some of Sunbelt's machines on a flatbed that Sunbelt did not send. So it was my experience through the whole project that when machines were moved, Sunbelt machines, it was always on a Sunbelt vehicle or trailer. But this time it was not. And then, lo and behold, what happened? What happened is that Sunbelt filed a claim of lien against my LLC's DBA, who had never been talked to or never gave any permission to be billed for all the dirt work and the machines. And they filed this lien and recorded it in the official records in Bradford County, Florida, to the property at 2501 Southeast 143rd Way, Stark, Florida 32091. And this is Terry L. Harrison, where there's the agreement that we should have had the deed long before now, but it was in the amount of $31,941.06. Now, we were being billed by the contractor, and the contractor was billing us directly. And this is the horse farm project here. And we paid the contractor here in full. Now the contractor's billing the LLC with no permission from the LLC or its authorized member. And continuing to bill, again, no authorization to bill the LLC or the DBA. But they were sending these bills individually to my husband's and my emails and asking us to pay, and we were paying the contractor, and we gave the contractor money to pay Sunbelt's machines. And so on December 4th, 2020, the contractor wrote that the labor is paid in full. Even beyond that, we paid to have other trees removed, trees that died because of the interruption of the contractor by John Mueller to take the machines for over a month or maybe a month and a half to two of John Miller's other properties. So now, being that my husband and I were being billed directly to our emails, which means I was being billed for this whole $31,000 plus, I wanted to see why was it over $31,000, because that's certainly, we did not rack up that entire bill, and we had paid the contractor to pay Sunbelt, and we had paid the contractor's labor in full. So I did what I had a right to do, since I was being billed directly to my email, and they could have come after me individually for this bill. What I did was I demanded that Sunbelt Rentals and their attorneys send me, which is done here, a sworn statement of account. And so they did that here. And lo and behold, what did we find out? We found out that all of the invoices were being billed to us at 2501 Southeast 143rd Way, Stark, Florida 32091. But lo and behold, buried in the middle of this sworn statement, we find out where John M. Mueller gets sneaky. Here is the job location is 5363 Southeast 122nd Street, Stark, Florida. That's not 2501 Southeast 143rd Way, Stark, Florida. This is one of John Miller's properties, billing all these machines to us to pay for here. John Miller is doing dirt work on his other properties, and he's billing us to pay for that. And here's another one. Here's another bill of John Miller doing that. And whoa, here's another one, a different property, John Miller property. 3955 Southeast 144th Street, Stark, Florida, is being billed. It's buried in the sworn statement of account, billing us for another one of John Miller's properties, the dirt work there and the Sunbelt machines. So two of John Miller's properties. John Miller is financially exploiting two elderly people, my husband and I, to pay for dirt work and Sunbelt machines at two of his other properties. And he's billing it to us. And here's another bill. Here's another one. Same John Miller property here. Okay, so you have absolutely documented criminal elderly financial exploitation being perpetrated by John Miller and Bradford County Telegraph against my husband and I regarding the Sunbelt machines that did impart some of the improvements we made to the horse farm at 2501 Southeast 143rd Way, Stark, Florida 32091. But by digging into Sunbelt's sworn statement of account, we found out that John Miller and Bradford County Telegraph were billing us for dirt work on Miller's other properties. And he hasn't been arrested for that. Yet, Florida has a very strong elderly financial exploitation policy. So that's a big question mark. How did that get let go? So, when the Petrona Farm LLC DBA, Best Horses Riding Lessons, who never authorized being billed, showed up on those bills, John Miller took money at the Bradford County Telegraph newspaper and published in the legal notices the fictitious name statement of Best Horses Riding Lessons, a DBA of Petrona Farm LLC, located upon the property at 2501 Southeast 143rd Way, Stark, Florida 32091. And so that was between October and December 2020. So clearly, John Miller and Bradford County Telegraph Incorporated knew there was a horse business located on the property, the LLC, and the Best Horses DBA. And they're maintained in the Florida Division of Corporations at the Florida Secretary of State for anyone to look up to determine if somebody else has an interest in the property, like my husband and I. So what came next? During late June, early July 2024, John Mueller hand-delivered here in what I believe is his handwriting, references the 2018 sweat equity purchase agreement for the property at 2501 Southeast 143rd Way, Stark, Florida 32091. And he increases the purchase price to $150,000 and makes an offer to do 100% financing on the property to us here. No mention of the application of the $415,331.50 sweat equity improvements that we put on to the property. Under some Florida case law, if an offer is hand-delivered by the person making the offer, that meets the requirement for the party to be charged signing the offer. On August 18, 2024, my husband and I accepted that offer that we just showed you in writing and had it attached to this acceptance. And so that offer and acceptance constituted a binding purchase-sale contract between John Mueller and Bradford County Telegraph, Inc., and my husband and I. So what happened next? John Mueller published in his newspaper an article on my horse business and me as a professional hunter-jumper trainer. And he published it in this newspaper. He published it on January 23rd, 2025. And in this article, he says that I own, see the word own, owns, approximately 10 acres on 143 Way off CR 100A. That's what he says. Bradford County Telegraph, Inc. owns the Bradford County Telegraph newspaper, and John Mueller is its editor. And they publish that I own the horse farm property, and this is notice to the world. But that's not all. What else did John Mueller and Bradford County Telegraph, Inc. do? On March 27th, 2026, John Mueller and Bradford County Telegraph dispersed the mortgage loan in the amount of $130,000. Disbursement of a mortgage loan is ordinarily considered the closing. And under Florida law, it brings an obligation upon the vendor, seller of the real property at the moment they disperse the mortgage loan. Under a concurrent duty, the vendor seller has an obligation to record the mortgage and convey the deed. This made us equitable owners of the property, and by operation of law, converted Bradford County Telegraph, Inc. into nothing more than a mere constructive trustee holding a constructive trust and bare legal title. And so it set forth an amortization schedule, and in the amortization schedule, the first payment was not due. See, no payments due in 2026. It was not due, the first payment, until 11/27/2027. But even more than that, this time, the whole series of writings that comprise our purchase contract and 100% mortgage financing contract, because this mortgage loan disbursement and amortization table were performance of the 2024 binding purchase and financing contract. And he signed it. So this constitutes the signature of the entire series of writings constituting our purchase and financing contract. He signed it to my executor. If something happens to me in the next 20 months, honor this document. John M. Mueller, March 28th, 2026. And again, here is John M. Mueller on the left. On the Bradford County Telegraph's Facebook page, John Mueller, who all those documents interpreted under Florida law, said my husband and I are the equitable owners of 2501 Southeast 143rd Way, Stark, Florida 32091. And Bradford County Telegraph, Inc., after the March 27, 2026 disbursement of the mortgage loan, merely holds bare legal title and nothing more, and holds it in constructive trust for my husband and I under a duty to convey the deed and record the mortgage. One thing that's significant about conveyance of the deed is that because of the rules regarding the property, until we have conveyance of the deed, I cannot give my writing lessons. And John Mueller has been dragging this out since October 29th, 2018, damaging my writing lesson income all this time. And so we were looking forward to conveyance of the deed. And he can't say all those writings do not exist. They do. And it's his documents, mostly. So here my husband and I are expecting to receive conveyance of the deed and recordation of the mortgage. And we make what's known as a United States District Court Rule 301G confer with John Mueller's and Bradford County Telegraph Inc.'s attorney, Charles Daniel Sykes, about our motions. Now, here is Sykes right here responding. Notice the date, April 15th. Here. On behalf of John Mueller, John Mueller's Revocable Trust in the Bradford County Telegraph Inc., we pose no objection to the motion. So he's making a 301G confer that admits that he knows there are pending cases involving the property, 2501 Southeast 143rd Way, Stark, Florida 32091, on the same day and 15 minutes before. By the way, this is Charles Daniel Sykes here. This is his Florida bar page. And this is Charles Daniel Sykes, public part of his Facebook page, your hometown attorney. He gives the confer about 15 minutes before this. Before Sergeant Glenn Ward, here on the right, Sergeant Glenn Ward, and Major Don Mueller show up outside in the driveway, already through the exterior farm gate, right outside our kitchen. No warrant signed by any judge under the Fourth Amendment. Nothing like that. Sergeant Ward shows up with a complaint to remove persons unlawfully occupying residential real property. It says, number one, I am the owner of the real property or the authorized agent of the owner of the real property. Well, that's perjury, because based on all these real estate writings, purchase, binding contract, and the disbursement of the mortgage loan, what's truthful is that he is the constructive trustee, vendor, seller, bare legal title holder of the property, and we are the equitable owners. Then he says the real property is a residential dwelling. Really? Then why is an LLC and a DBA doing business on the property? And even if there's a residential dwelling, what about the rest of the 10 acres that's a horse farm? Then it says, we are unauthorized persons or persons who unlawfully entered. Well, they know that's not true because Dylan Harrison, on behalf of his mother, Terry L. Harrison, voluntarily gave us possession of the property, and John Mueller ratified that probably over 50 or 100 times coming on his golf cart over the years, including making the 2024 offer to purchase the property and 100% financing in the 2026 disbursement of the mortgage loan. And so he never directed us to leave the property whatsoever. There is no writing that tells us to leave the property, so that's perjury. Then he says that we are not an owner or co-owner of the property. Well, we are equitable owners by virtue of the disbursement of the mortgage loan. So that's perjury. Because it's a half-truth. Half-truths are perjury. You've got to give the full disclosure. Then it says, this is the biggie, there is no litigation related to the real property pending between the property owner and any person sought to be removed. Well, that's a lie. John Miller's own lawyer is admitting and responding to this case pending about the property in a 301G confer right before the complaint is executed, that there is pending litigation. See, this is from Dan Sykes, Charles Daniel Sykes. Says, I have read every statement. Each statement is true and correct. They're being made under penalty of perjury, punishable as provided in Section 837.02 Florida statutes. And then it's signed by John M. Mueller. And so what you have is John M. Mueller and Bradford County Telegraph, Inc., who are vendor sellers of the horse farm at 2501 Southeast 143rd Way, Stark, Florida, 32091, are taking a knowingly invalid and perjurious cheap shot squatter complaint to try to oust the equitable owners from my husband and I from the property we purchased. Under Florida law, vendor sellers can only oust property purchasers who are given possession under color of title, which is what we were, by the only and exclusive remedy in the circuit court of an ejectment action. Nothing else has jurisdiction. But we would have gotten a pre-deprivation court hearing before he could do that. And maybe he wouldn't have been allowed to do that because we have all these documents and they're his own documents. So, one of the important things I want to say about this video is this is how John Mueller, Bradford County Telegraph, Inc., their attorney, Sykes, Sergeant Glenn Ward, and Major Don Mueller, who is in charge of Bradford County Animal Control, got access to my horse Gulliver, my 30-year-old horse Gulliver. This is how they got access. No warrant signed by any judge under the Fourth Amendment. No exigent circumstances. A perjury-laced squatter complaint with no jurisdiction because we were purchasers of color of title with equitable ownership because of the disbursement of the mortgage loan by operation of law. Bradford County Telegraph, Inc. had become merely a bare legal title holder constructive trustee that was under an obligation to act for the beneficiaries, which was my husband and I. So that's point number one. This is how they got access to Gulliver, to intentionally kill him. But point number two is also very important. And anyone living in Florida knows anything about the horse industry in Florida knows it's around an over $40 billion industry. Many, many people come into Florida and buy horse farms in Ocala and Wellington and Loxahatchee. And based on what was done to us, anyone moving into Florida to buy property with animals, anybody trying to buy a horse farm in Florida, no matter how wealthy you are or where you're trying to buy that horse farm, or even other types of farms with livestock, if you have made improvements to the property, or if the property is wildly appreciated since you signed the purchase contract, well, this, what happens to us, proves you're not safe. No one should be buying any property in Florida, and certainly not for animals, certainly not horse farms, because any proper vendor, property seller can do this to you. In fact, because nobody will look at the perjury statements on the face of that squatter complaint, you could hold the deed, and some just unknown person could walk off the street, swear out a squatter complaint, give it to the sheriff. You would be walked off your property. Your property. And this creates a crisis in the housing market in the state of Florida. And yes, our Governor Ron DeSantis should have known about this. He never should have signed that bill. And furthermore, since Casey DeSantis had breast cancer and is such a good advocate for women who get breast cancer, well, when we were walked off the property, Sergeant Glenn Ward wouldn't even let me take my letrozole breast cancer medication. And since we were walked off the property, John Mueller and Bradford County Telegraph have taken around $15,800 of Verzenio medication for my breast cancer. So, this newfangled Florida law, it can devastate any home buyer who wants to buy property in Florida. And that's how it is. But that's not all. Because here we have the Bradford County Telegraph again, June 4th, 2026. That's this newspaper, owned by John Mueller. And here it is advertising the property of which we are equitable owners, of which no bona fide purchaser for value could take without notice because of the extent of the Liz Pendens, the Secretary of State records, all these purchase contracts, the newspaper article to the world that I own it, and he's trying to sell it, get this, for $300,000, doubling the price, and he's pointing at the sheds and fencing that's our improvements, the $415,331.50 improvements, to sell it for the doubled price. So that's the end of video part 1 about who killed Gulliver and how they got access to Gulliver to intentionally kill my 30-year-old autism horse Gulliver. Stay tuned for part 2. Thank you for watching.